Hello there, a very good evening and welcome to another episode of The Role of Law. On The Role of Law, we've been constantly speaking about constitutional change, of course, because that is the talk of the town and it affects each and every citizen in Sri Lanka. The 20th Amendment to the Constitution is in its final stages in Parliament. This amendment, as you all know, was challenged in the Supreme Court, and the special determination of the Supreme Court on the constitutionality of these provisions and if or not they need to go to a referendum is out. And here to discuss this special determination of the Supreme Court, we have Professor Prathiba Mahanamahewa, the Dean of the Faculty of Law at the University of Technology in Jamaica. A very good evening, Professor, and welcome to our show.
Good evening.
Professor, speaking on this special determination of the Supreme Court, one must first understand how the procedure works. Why were these petitions filed in the Supreme Court, and what really can the Supreme Court say? Because during the hearings, there were submissions made that some of these proposed amendments to the Constitution are so fundamental, they so fundamentally change our Constitution that they cannot even be passed by a two-thirds majority and a referendum of the people.
Now, basically, any amendment which introduced to the Constitution, there are certain stages to be followed. So that's why gazetted. The first stage, the cabinet approve it and then gazette. Then people know it. So there is a open provision for the interested people can go to Supreme Court under fundamental right provisions. That is where you call, if this amendment passed or if this amendment is placed, it will contravene with the Constitution. That means, for example, one amendment A, if passed, it can go against the Constitution.
So these are specifically the entrenched provisions in Article 83.
83. So that is basically what we see. These are all fundamental right applications. What I mean, it is going against the Constitution. So once the Supreme Court get that applications, petitions, there were 39 petitions. So all the petitions, Supreme Court critically analyzed and heard the arguments, got the written submissions. Finally, the Supreme Court give their determination to Honorable Speaker as well as His Excellency President. And then the Supreme Court basic determination is read by Honorable Speaker in the Parliament and then go for the debate. Now, one thing I like this time, we are very democratically, I have seen the Attorney General introduced many provisions that come in the committee stages. Very interesting. Earlier it was not there. So the government gazetted, and thereafter big debate happened in the society, civil society organization.
Even among the government
members. So that is a very plus point I want to show you. So positively, this committee stages amendments were actually introduced, which was I think the Supreme Court also really appreciating a situation like that. So Attorney General really mentioned these are the things coming in the committee stages, so nothing to hide by the government side now.
But Professor, is there a guarantee that these committee stage amendments will be made?
Very good. I think this government we can trust, the President we can trust. So that is where they said basically we will listen to people, we will listen to others, and we will try to introduce. The guarantee is there in the Parliament. So once again, you can't, after the committee stages, not a single citizen can go and petition this. The question you asked, whether these were incorporated or not. Honorable Attorney General introduced in the Supreme Court, but it was not followed. I think basically they will follow it because that's why they openly said it. And then it go to the two-third majority once again. But in some countries you have judicial review power. ultimately Sri Lanka very restricted this judicial review power. In those countries, they once again can see what happened if any changes are coming. So I think the people are aware, Parliament is aware. Once again, I want to tell one thing. I think this is only an interim measure, 20th Amendment. So I saw in news, before the President second term complete, they will come up with a new constitution. So here,
so before the end of this term of the President?
Yeah, when it comes for the second term. And this is where a very positive one. So I think President need the freedom, because Constitution Council, once again, those things are barriers to him. And even think this way, the President also coming with the people mandate.
Professor, let's speak about
69 lakhs. So therefore, we have to listen to him. And 1978 Constitution, the powers are given, duties are given. Let's see how he works, even at least 1 or 2 years.
Professor, the Supreme Court determination is out. We don't have to speculate on what will happen, what won't happen. Let's speak about specifically duties of the President enumerated in Article 33 that was sought to be amended by Clause 3 of the 20th Amendment. Now, Clause 3 specifically removed a section of these. But before we get into that, Professor, just to make it clear to the general public, the Supreme Court will decide on whether or not there is a need for a referendum to be held for certain of these provisions to be passed. There are no such provisions that cannot be passed in the Parliament of Sri Lanka, are there?
Yeah, that we will little bit elaborate.
Okay.
Now, when these 39 petitions were heard by the Supreme Court, and then what will happen, the Supreme Court determination very clearly say, these provisions you can pass by 2/3 majority. These provisions, 2/3 majority is insufficient, you must go for a referendum. So that is the basic determination after looking it. So we can see certain provisions, yes, fair enough, you can go with 2/3 majority. But some, the Supreme Court determination clearly say 2/3 majority and a referendum. So the government party now can decide whether go for a referendum or whether we go with 2/3 majority, and you can drop it and you can, craft it according to the Supreme Court determination. So that's why the rule of law is above anyone.
Right. So now getting into the substance of the special determination of the Supreme Court, as I mentioned before, Article 33, it lists out the duties and responsibilities of the President. Now, Clause 3 of the 20th Amendment sought to remove some of these. Some of them, among them, was one of the articles, or the sub-articles in that section, that said the President is responsible to create an environment to hold a free and fair election. Now, the Supreme Court has specifically said that removing this provision would require a referendum. The reasons for this?
Yes, I think the Supreme Court has really gone through, because we had the Election Commission, and also why the Supreme Court has determined in such a way, because most of the media sometimes, maybe the government media, may be biased or may not be biased, and even they are restricted for certain type of clauses. So what has happened really here, the Supreme Court may have thought it is better this commission should keep that power to have a fair election, and the President also supporting for that. On the other hand, so the President is leading that, and President giving the example, as well as it has to be subsidiary by the Commission also can give the direction.
Now, what's interesting is the fact that the Supreme Court has only said that this removal of this provision needs a referendum. The removal of the other duties of the President does not need referendum. And the reasons that the Supreme Court has highlighted in the special determination is the fact that it is, of course, desirable to have the duties of the President listed out in a separate section instead of people having to go through the entire Constitution and realize what the President's duties are. But the Supreme Court specifically said that they are not bound to decide on desirability, only on whether or not it affects the entrenched provisions in Article 83.
Yes, now, so if you talk about President's duties, all are listed in Article 33.
Yes.
So you can see the list very clearly. and also people can read it and get the idea how in simple way, starting from the command of the three forces and declaration given and war, as well as fairly handle the government system. So all these things are there. But I think when it comes to the election, the directives, Supreme Court may have thought after listening to all the petition, it is better with President as the leader of the country, as the executive of the country, can move it, but still it can be further expanded to the Election Commission to give those directions. Then it will be fairly done, President one side as well as the Commission doing their duty. So it will be collaterally work together. That is my opinion.
Another provision in the 20th Amendment to the Constitution that the Supreme Court has discussed in length in the special determination is the immunity of the President from suit. Now, this is quite interesting because even when the Gazette was published on the 20th Amendment to the Constitution, this sparked a lot of debate among the people. Government faction said the President needs the freedom, he can't waste his time in court. But however, the Supreme Court has determined that for this clause to be passed into law, there needs to be a 2/3 majority in Parliament and also a referendum.
Let's see 1978 Constitution originally what the President immunity. It's clearly say Article 35, 1 and 2. And thereafter you can see after the 19th Amendment was passed, clearly you can see with the amendment what happened, Article 35, 1, 2 and 3.
There was a proviso.
There is a proviso. That proviso, now President immunity is very clearly say in the 19th Amendment also. Now if you take 19th Amendment, it is clearly say, while any person hold the office of the President of the Republic of Sri Lanka, no civil or criminal proceeding shall be instituted. It is very clearly say. Or continued against the President in respect of anything done or omitted to be done by the President either in his official or private capacity. The proviso say provided fundamental right application can be filed against the President. That's why it say very clearly, and Article 126 against the Attorney General in respect of anything done or omitted to be done by the President in his official capacity. So likewise. Now when you see this, okay, now what will happen if you want to remove the immunity? That's why the amendment tried. But you said perfectly it has to go for a 2/3 majority as well as for the referendum. But let's see, same thing was there in the 1978 Constitution. Even the 1978 Constitution originally it didn't say about the fundamental right application cases. I will come one by one. You know, Karuna Tilaka versus Disanayaka case, when the emergency regulations and other election period came up. So the Supreme Court said they had the judicial review power to review the action of the President. And also Vikram Bahu versus Hera. In that case, what happened? In a May day, it was banned. And thereafter the President action, whatever, reviewed by the Supreme Court. And 1997, Silva versus Bandaranaike, it was appointment of a Supreme Court judge, but leave to proceed was not given. But even that, lot of cases are there like Joseph Pereira versus Attorney General. Those were before even the immunity was there. Immunity was there, cases were filed against the President. Even the cases came up, his action, not as a person, his action judicially, review power was there.
Because immunity protects the doer, not the act.
Not the act. So doer protected. So the action can be questioned.
However, the Supreme Court has dealt with this area in their determination. They have said that even before the 19th Amendment to the Constitution introduced this proviso, the Supreme Court in their decisions have made inroads into the President's immunity. But however, the Supreme Court has said that since this is not hard law, Supreme Court decisions aren't hard law, and they could be overturned by a decision of the subsequent Supreme Court. They're of the opinion that this pulls back on the sovereignty of the people and their right to a remedy for a breach of their fundamental rights. And that is why they need to go for a referendum.
And another thing I just want to mention, even this 19th Amendment incorporated this fundamental right application as a proviso which was there before also. That's why I just want to tell you. So even with the referendum passed or not, I am not sure what will happen, but still under 1978 original constitution, before the 19th amendment, there was no blanket immunity. This is not a ouster clause. This is where president action was questioned in the Supreme Court. So that's why I can give a list of Supreme Court cases. All these Supreme Court cases, even Visholingam case, it was clearly said in the Supreme Court, action can be questioned. So that's why this question is coming under fundamental right cases. Under the Public Security Ordinance, President declared the emergency and it passed by the Parliament, but emergency laws cannot overrule the fundamental right of the people. Where fundamental rights were breached and action has been happened. That's why Attorney General is appearing on these cases. So I mean, the amendment put it very clearly, but the immunity for that, you have to go for a referendum. But my argument is, even you keep the 19th amendment or you keep in the 1978 original constitution, president actions question in Parliament before the 19th amendment. There is no two words about that.
So moving on to some of the other provisions that have been dealt with by the Supreme Court. Clause 6, it dealt with the Parliamentary Council and the removal of the Constitutional Council. Now the Supreme Court had to peruse through quite a lot of previous cases for this matter, the 17th Amendment, the 18th Amendment and the 19th Amendment special determination. Among the general public, the discussion was that the same MPs who voted for the 17th, voted for the 18th, they voted for the 19th, now they're voting for the 20th, which principally dealt with this element of the Constitutional Council and the powers that have been vested with the Constitutional Council. Just to give a brief overview of what really happened, the 17th Amendment introduced the Constitutional Council that introduced checks and balances to the President's discretion on appointments to high offices, including the Inspector General of Police and the Attorney General. The 18th Amendment did away with all of this. The 19th Amendment reintroduced it. The 20th Amendment, we're doing away with all of this. Why are we going back and forth on this?
Before that, I would like to respond one thing, people, why they voted 1780 then 19. People are changing. That's the nature.
People are changing?
People has to change.
The biggest problem was that the same parliamentarians in Parliament voted for the 17th.
Doesn't matter. That is the nature of politics. That is the nature of governance, right?
But where is our policy?
Policy should be there. But if the people see, if the people vote, yes, they have elected. So therefore they can vote. That's a freedom of voting. That's a freedom of expression, we can't say. But as you say, ethical manner or legal manner, there can be fixed things. But still we can't criticize, don't vote for this one. And
there are no bars to the discretion of the parliamentarian.
That's why this independent one of the commission member also went for this petition. So why people are doing like that? If you call so-called commissions, he has used this vehicle from, this is government vehicle and I am not going to criticize that. People are there like that. So this Constitution Council also, they try to take a 19th Amendment to get a blanket immunity. But the Supreme Court said you can't give a blanket immunity for the Constitution Council. When the argument came up, still their actions can be also questioned. But
right.
Yeah.
Okay.
That's the situation. So, but what I am going to tell you now, the Parliament Council will be set up soon after this. So, the Parliament Council actually helping the President to see the observation. Even President will nominate certain rankers or higher positions. So those things even President name, but the observations can be done by the council. So that's how I see checks and balances come. You may not agree with my argument totally, but I mean there must be some monitoring institution must be there. So I propose Parliament Council take an active role because opposition leader also there. This is happening in other countries also. When appointment of judges, Parliament Council like that, one council is there. Government as well as in Jamaica or even Australia, President name the Supreme Court judges and it go to the Parliament Council, and even USA you can see it. So I mean, if the Parliament Council do an active role, the opposition leader can do some active role, and then you can give your observations rather than saying, no, I am not going to that one, I am not participating. So people need your participation. So do an active role. then only you can do it, or even proactively you can do it before that.
Of course, the Supreme Court has said that there is no inconsistency with the entrenched provisions as far as the abolishment of the Constitutional Council and the introduction of the Parliamentary Council goes. Let's move on to another key power of the President, which the Supreme Court again has said that is not inconsistent with the provisions, the entrenched provisions in the Constitution, which is the power of the President to appoint the Prime Minister and to remove the Prime Minister, to appoint ministers, and also the removal on the cap on the number of ministers. The Supreme Court has said that the President is the repository of the executive power that he holds in trust for the people, and empowering the President to make these appointments and to remove people who he thinks has lost the favor of the majority support in Parliament is not inconsistent with the constitutional provisions.
Yes, I agree with that. But you know, there was a case sometimes back, former President Chandrika Bandaranaike was there, Water's Edge case. Public trust. Even the President cannot breach public trust. Those are some example cases I am mentioning. Even the full authority is there under the Constitution. President also as the trustee of this country and take the public trust very high. So removal of these bars, President has the freedom to do it. That's why we come into the 1978 Constitution originally, appointment of the Prime Minister, and you know, barriers were there for the 30 members that also removed. So now President can think within few times how we are going to develop the country and what type of necessary things for the country. So that's why my argument 30 was a restricted, but I can't say what is the government policy, but still I think they abide by a low number, low profile of cabinet ministers to run the country. That's why people are expecting and also save public money.
Moving on to another provision, Clause 15, Clause 27 and Clause 28. They deal with the publication of bills and also the urgent bills provision. Now, the 20th Amendment is proposed to reduce the time period allotted for citizens to obviously go through these amendments, these bills that are being proposed in Parliament, from 14 days to 7 days. Now it can be gazetted on a date, and within 7 days can be placed on the order paper of Parliament. And the Supreme Court has said that this does not oust the people's power to come before the Supreme Court, and thus is not inconsistent with any entrenched provisions. Your thoughts?
Yeah, I think this is where we should also vigilant as people, organizations, civil society and other organizations. We have to see what is happening in the government action. Sometimes what the Supreme Court has done, look in the foundation of the 1978 Constitution, and that's why they have said not inconsistency and move on like that. And on the other side, government also have an ethical and moral obligation when it's coming up. I think some urgent bills are there. For those things, you know, once again it comes to the Parliament. That is the way you prove it. But we have to use the Parliament or even the government must use their authority for the best of the country, best benefit of the people. Then only we can go a country like Singapore and Cuba.
Also, something that really caught my eye in the Supreme Court determination was the fact that the President can submit certain bills that he sees as urgent in the interest of national security to the Supreme Court to be reviewed within 24 hours. And the President can extend it up to 3 days, but that is also at the discretion of the President. So technically the Supreme Court is given 24 hours to decide on the constitutionality of a bill. And the Supreme Court has said that expediting the process of judicial review, pre-enactment judicial review, is not a violation of any constitutional provisions, entrenched provisions.
Yes. Now we have faced a war sometimes back. In future also we have seen ISIS and other guerrilla movements are coming, and it can be a cyber war even. To set up for that, yes, the top and the priority for the country is the country security, nation security, and we have to protect all the citizens in the country. So therefore you can't drag these things for a long time period or even within 24 hours. That's why the Supreme Court also have determined like that. This is necessary for a country which is facing in a trouble period. It can be COVID-19 even. It can be another disaster. It can be a pandemic. It can be a war. For those things we need urgent bills other than the food security, even cost of living, that you can address in the Parliament. But certain things are there, yes, you have to expedite it. So I totally agree with that.
So the Supreme Court has placed a lot of emphasis on the powers to ensure a free and fair election, as was seen in the initial, what we discussed at the beginning, Clause 3, that removed the President's duty to ensure a free and fair election. Supreme Court said that you cannot do that without an approval from the people at a referendum. Let's speak about another provision in this that was challenged before the Supreme Court and that the Supreme Court has discussed, these guidelines that are issued by the Elections Commission on media institutions. The Supreme Court said that there is no inconsistency there, as the guidelines and the duty to ensure that these guidelines are respected is on the media institutions, and there is no specific method of enforcement or penalty that follows any of these guidelines or contravening any of these guidelines that have been issued. Your thoughts on that?
Yeah, now I think fair election, we need independent institutions. So my thoughts are basically free and fair election, one side the government also there. So on the other side we have to see some independent body also. That's why former election department now set up with the election commission. So parallelly those two must have to work. So government also can introduce several guidelines, and it has to be go to the election commission, and the election commission also look this one, and I think they must correlate that, and with the discussion, with the ministries there and the commission, rather than very independent commission we think in future. So if it works like parallelly, this will be a good prospect for the Sri Lanka.
Of course, the Supreme Court determination has been published, and this is not the end, of course, for the 20th Amendment to the Constitution. There will be more committee stage amendments that are coming in, and unfortunately, given the fact that there is no post-enactment judicial review in Sri Lanka, none of these committee stage amendments are reviewable.
Yes, that is the biggest challenge we face. So we have seen now one, and Supreme Court determination given, and then we have the committee stages. I think this is very transparent. What I say, Attorney General submitted to Supreme Court, and Supreme Court also has seen that and also mentioned in the I have seen in the judgment committee stages this may be come up. So that means there is a trust and confidence. So the only thing in the committee stages after changing these things.
So but then the Attorney General did not say that these are the only amendments that are going to be brought in the committee stage. More things will come.
We'll see in the two-day debate and how it is coming up. In the two-day debates also some positive things may come up from the opposition and the other society people, and we can incorporate that. But I think rather than restricting those things, you have to expand that in the committee stages. And look, only the parliamentarians are there to vote. So other than that, in Sri Lanka, according to the 1978 constitution, we have no provision to challenge that.
So, like you said, this is only an interim measure. We are in the phase of drafting a new constitution. So, post-enactment judicial review would be a much needed provision to be included in this new constitution that we're all waiting for.
Definitely. I think we have a very good model constitution, 1996 South African constitution. We had several workshops with South African embassy sometimes back, and we have seen how they have drafted. So you can take South African constitution and the Indian constitution one side and see how this judicial review power, if the government is thinking and it has to be passed by a referendum, how to incorporate that. So I think those things are new things we have to see. And another thing I would like to tell you, fully change the fundamental right chapter. Chapter 3, you have to reinstitute, reconstitute, right to life is not there. So several
right to privacy.
Right to privacy, yes. That is where in the pandemic period, people are asking whether journalists can take photographs and how they can fight for that. This is a right to privacy, even in the image. So these things, they must look and take time and come up with a new constitution draft and go to the people. And thereafter you can go with the process, but it will take some time. If the draft is out, definitely people and others, they can give their, yes. But I think as citizens we have a duty now. After passing the 20th Amendment, let's set up for the new constitution. So I encourage public, I encourage education to submit their report, to submit their recommendations to the Minister of Justice to see the new constitution. Don't stop it now, 20th Amendment. After passing, what will happen? We all have a duty. We will give our recommendation. Then it is easy for the government to draft a new constitution, taking consideration all these new ideas.
Thank you very much, Professor Prathiba Mahanamahewa. You came here to discuss the Supreme Court determination, but I think you've done way more. Thank you very much once again, Professor, for joining us on our show. And thank you very much to all our viewers out there for tuning in to The Role of Law. Of course, for everything in the field of law, The Role of Law is the program for you. We will be back again, same time, same place, next week. Until then, take care and God bless.